How about color, right? The Louboutin Soul, the Smurf Turf rather, up in Boise, or the green and yellow of John Deere, right? So colors, single colors or multiple colors. Here's an interesting one about this. Product configuration, that is shape of product, right? The PlayStation controller, okay? That is very distinctive and pointing to a source of products. The one in the middle is a luggage store layout. It's a store layout, the actual arrangement, appearance of a store. This one is for a luggage store that's shaped like the inside of an airliner. You've probably been inside an Apple store or at least seen it, right? That layout as well. So last time I checked is also protected. And then on the right, no, that's not pasta. That is a corn chip. So if that was just pasta, probably not distinctive, right? Because a lot of brands make pasta in that shape. But if it's a corn chip, yeah, now we're looking at something that's a little more distinctive because that's not something you see typically. Okay, so we talked about sounds. We talked about color, packaging, product, or store design. We talked about that a moment ago. We didn't talk about scent. Yes, aroma or scents, like Play-Doh scent, can be as well. It's super rare because, as you can imagine, when's that going to work? But scents may be as well. The whole point is, you think about anything that can really be distinctive and identify goods or services may function as a trademark. I do have one little note on this slide. You know, when we're talking about colors or really product or packaging design, now I didn't show packaging design, but think of like the Sugarfina bento box, if you've ever had that candy, or maybe Coke's Hourglass glass bottle. Packaging, not the product itself, but the packaging, but very distinctive. So colors, product configuration, packaging, these sorts of things, you might have heard the term trade dress. It's a species of trademark. They're really trademarks, but those types are often referred to as trade dress. Now, protection. Trademark rights arise from use, not a grant from the government like a patent, but use, okay? Not necessarily a registration. There's a registration available at the federal level and state level. They typically enhance rights, but don't create them. But there are a few benefits. Those are on the slide here. You can pause that and take a look a little bit more. It could be very valuable, but they're not created that way. Trademarks have to be used to function as trademarks. If they are, they may have rights, and you're well on your way. Now, copyrights. This is kind of column 3. Now, copyrights protects what we call works of authorship. That does not mean that you're just writing something, though. That's just the legal term. Anything that an author creates that is fixed in what we call tangible medium, which could be paper, could be something digital, but it's just not here. It's fixed. If it's fixed and it's independently created by that author and has just a tiny amount of creativity, and when I mean creativity, that's not a subjective judgment on how fanciful it is, but just something expressive about it, something other than just kind of rote facts of nature or what have you, that's probably going to qualify it for copyright protection. So what are we talking about here? Let's take a quick look. Right here, we see on the left, we see a digital ad, right, with a lot of different content in it, a lot of visual art in it, you know, a lot of elements. That's protected. But that incorporates another piece of vector artwork in the center, which itself, as a piece of vector artwork, has copyright protection. And that vector artwork itself was based upon a photograph of a human on the right, and the photograph has copyright protection. So you can see how copyright really can, you know, ooze all throughout a lot of different works of authorship out there, and really kind of be ever present. What are we looking at here? This is a belt buckle. Copyright, Andy? This sounds like a utilitarian device. Is this like a patentable thing, something like that? Well, no. If you think about this, yeah, it's a belt buckle. It has utility. It has function. But conceptually, it's kind of a sculpture, right? It's a piece of artwork, and you can kind of conceptually pull out the artwork and pretend it's not on a belt buckle. It doesn't have to necessarily be on a belt buckle. So, and it's good that this was protected by copyright, because that, if it weren't, then I probably would have had trouble talking about this particular right with a big company that somehow managed to, wink, wink, have nearly the exact same piece of artwork on their belt buckle a little while later. So it's good that copyright can protect some utilitarian items, but that can be a little bit complicated. Now, really quick, the types of works, they are various. Literary, I mentioned musical works, including the lyrics, not just the notation, scripts and screenplays, choreographic works, pictorial, sculptural, visual art, audiovisual works, sound recording, the recording of sound even, not just the notation and the singing, or the lyrics rather, but the actual recording is a work of authorship. And then architectural work. So you can see it's a big subject area that's covered by copyright. What's not protected? These things, just basic ideas, systems, processes, right? That sounds like the thing that you might be able to protect by patent, but not copyright, right? Only expressive works. The US government, it's real simple, they can't own copyright. So if you just want to happen to print out your own versions of the tax code and sell them, if anyone's buying, probably can do that. That's not legal advice. Go get it from an attorney if you really want to do that, but most likely going to be okay. Typefaces, I never see this come up in the real world, but they cannot be covered by copyright either. How do you get it? Kind of like trademarks. Now, I told you patents have to be issued. Trademarks, from use, registration makes them better. Copyright, upon creation, copyright magically attaches, the protection attaches. However, registration can make copyrights much stronger. And there's a couple of reasons right here listed. I'll have my contact information at the end. If you have any questions about these kind of benefits, I'll be happy to answer those later. But just the protection itself, no formal registration is needed, but to be sure, registration makes them stronger. Fourth type, okay, trade secrets, right? Again, I mentioned earlier, trade secrets basically means it's information, right? It's information that is secret, kept secret through reasonable, not utterly exhaustive efforts, but at least reasonable efforts. And it has some value because it's not known to your competitors, right? It gives you a competitive edge. There can be a lot of information that you as a business holds and keeps secret, but if it doesn't really give you a tangible competitive edge somehow by not being known by others, it may be secret information, but it's not a trade secret with legal protection, okay? And a couple of the famous ones, you've all heard these, the Coke formula. You may not have heard of Adobe source code, but that's one of them, KFC recipe. And then if any of you have had chartreuse before, I don't think I ever have. It's kind of a green liquor that's made, I think, in France somewhere by some monks. I hope I'm not butchering that too bad. That's been a trade secret for, I think, 400 or 500 years. So trade secrets have, as you can guess now, have the possibility, so long as they're kept secret and can't easily be reverse engineered, can potentially last a long time. All right, mentioned this, I alluded to this a moment ago. How do you create one? Again, these aren't granted. There's no registration process. Whether you have a trade secret or not is purely a function of whether you have information that you do in fact keep secret. And how do you do it? You can you can hide it, you can tuck it away, but that's not always going to work when you have a functioning business. So doing things, you're gonna have to have other people know, right? So marking confidential, limiting disclosure, use of confidential agreements, NDAs, that sort of thing helps a lot. Now, best practices. I'm almost done, we're near the end here. I wanna talk about some things. How do you do it? Now, I mentioned you don't have to register copyrights, you don't have to register trademarks. However, if the situation is right, let's put it that way, it may be very advantageous for you to do so because it does strengthen your rights. So that's one thing to consider. Similarly, well, you may have great ideas that might, may mature into a patent, but if you don't apply for it, you're not going to get it, and it's likely going to go into the public domain at some point, or be snaked by somebody else later. So if you've got something that's a real potentially valuable, patentable material, you want to approach, or at least evaluate whether it's smart to apply for patent protection. Trade secrets, if you got them, identify them. Sometimes, you have to just sit there and think about what are my individual valuable secrets, plural. Identify what they are, and then inventory what you're doing to actually protect them. Are you keeping under lock and key? Are you limiting disclosure? Are you entering into agreements with not only your employees or contractors, but your outside vendors, maybe the people that build stuff for you, etc. They need to be under contract to do this. Trademarks and copyrights. Another thing to do is let people know you're claiming copyright protection. Freeze this slide. Here's an example. You've seen this before of telling people, I have a copyright here. That tells people to back off. Or with trademarks, whether you have what we call a common law or unregistered trademark and then a registered trademark. You've seen the notices there before. That does have an effect on third parties who might otherwise look to be quote unquote inspired by you, maybe a little too much. This is a little bit of a subtle warning, or maybe not so subtle warning, for them to steer clear. And then open your eyes, watch what's going on. Now, it's not very hard these days to just, everyone puts around on the web, look and see what competitors are doing. You will probably find or uncover or discover problems or potential problems along the way just by looking. If you want to have someone else do it, there are services out there, these watch services, that you can pay on a monthly or perhaps annual basis to kind of monitor things and spit out reports at you with potential issues that allows you to evaluate it. This kind of penultimate one here, you may know what you're doing, but make sure the people around you, your subordinates, your colleagues, they know what they're doing as well. Because even though you may be doing the right things to protect your IP, they may be stepping in it by not protecting it, or we'll talk about it in a moment, stepping on someone else's toes on your behalf, even though you don't want them to. And then enforcing your rights. A lot of times it's one thing to watch and look and see what other people are doing, but if you just sit on your hands when you're facing a big problem, that could actually turn into a loss of rights. Because as you can imagine, if you decide at one point to enforce some rights against a third party, and it comes out that you've been sitting on your hands for the past 5, 10, 15 years when other people are doing it, courts are going to be a little reluctant to help you. They're going to ask why. Why should I help you if you haven't been enforcing your rights all this time? Why now? So it's something you can't spend yourself into bankruptcy enforcing your rights, but you definitely want to pay attention and then evaluate what you should do with a professional. All right, avoiding others. So avoiding problems with others. 1, clear your rights. That is, if you have an idea for material you're going to create, trademarks you want to adopt, patentable material, you need to make sure that you have freedom to operate, right? You want to make sure you clear it. Make sure that you're not going to stomp on someone else's toes. You can do that a little bit yourself. Your common sense will guide you. But when you get on the 5-yard line here, you most likely would be benefited by talking to a professional to give you, are you ever going to be 100% sure? Probably no. But you can get awfully close, and frankly, awfully close is pretty good to give you that kind of peace of mind that you're not going to be surprised with a cease and desist letter. So that's what you're looking to do. Clear. And then I mentioned a moment ago, implement policies, not just to protect your IP, but also so you don't have errant subordinates and colleagues doing things that they might think is funny and cute and what have you. Next thing you know, they just exposed you to liability by being careless. So you want to think about procedures to have control to avoid infringement. Why does it all matter? At the end of the day, yes, either your value is going to go up or maybe stay the same, or maybe go down if you're not really on top of your intellectual property. So I hope this helped. Hope you know a little bit more, get a little more comfortable with the topic. If you have questions, snap the screen here. You can reach me. That's my office line, my direct dial. My email address is right here. And then if you're interested more in this topic, I have a Facebook group where some of these topics, I have short videos and there's discussion in there. That Facebook group is called Defending Your Brand. You can find that quite easily. And then Instagram, I do post some IP topics, little snippets, little videos, things like that. Attorney Andy Nelson is my handle, I guess, and that's pretty easy to figure out, easy to find me. Anyway, I hope this is helpful. Again, if you have questions, please reach out. I'd be more than happy to clarify and illustrate any of the things that I talked about today. Thanks a lot.